Guys, you're so quiet. Am I alone in this meeting? Please communicate tujue kama kuna watu, because it would be fruitless for us to come here and talk alone. Kindly confirm you together with me. And thank you, Magdalene, for recording. Tuko pamoja.
Yes, tuko pamoja.
It's so quiet. I feel like I'm
Yes,
talking.
we are together.
Okay, so any question on civil so far? And how are you finding KSL before we proceed? Nyongesa, how is KSL for you so far?
Okay, so far KSL is okay. So far it is okay, because I think most lecturers are now on introductions. It is not so bad at the moment. Okay, thank you.
All right, thank you. Mwema Brenda, how is KSL for you? Kipto Brian.
For me, KSL is quite engaging, more than undergraduate.
Could you expound on what you mean by more engaging?
The classes are more thorough. Like when lecturers ask you a question, they expect you to give a legal opinion, not what you think. Like they need something substantial about the law, not just anything else.
That's good. That's good to learn. Akinyi Faith, how is KSL? And maybe after you, Mwangi, can follow. I've seen you raised your hand. Akinyi Faith, how is KSL so far?
Yes, good evening.
Good evening to you too.
KSL is there. Let me say it's bulky. It's not as hard as we thought it is, but it's so bulky that it can almost be confused as hard. And the time is really short, but it's a nice experience.
Yeah, that's true. We said that on our first meeting the other week. Yeah, it's just bulky, but it's not undoable, and you guys will be okay. You have to go through the experience. It will seem tough and bulky, but then at the end of it all, you will come to appreciate you to go through that process. Mwangi, you had raised your hand. Mwangi. Any other person who wants to share their experience in KSL? Okay, I can see Mwangi.
Okay, so far it's good, but now we are waiting for the project work so that we can really test the waters. That's what I can say.
You don't anticipate so much with the project. It will come and itaudhi. So enjoy the freedom ya sahi. Enjoy the freedom ya sahi. Usikuwa anxious sana. Project will come at its own time and you'll have months to work on it. But yeah, thank you for those who have shared. But I hope KSL is okay for everyone. Okay, maybe not okay, but I hope you're coping up. So first forward, we'll start. So today we'll be going through pleadings and application. I'll take you through pleadings and then Angelo will take you through applications. So we decided not to go like into the introduction because those are very, very general things that we don't have to come and repeat here, like demand letter, because it's something you'll do here in civil, you do it in legal writing, you do it in almost most of the units. And yeah, so we just go into the flesh of civil by starting off from pleadings. Anyone who can tell us what a pleading is? Anyone who has an idea or just anything about pleadings that you know from undergrad or from your further reading? You can raise your hand or you can just unmute and proceed.
Okay, I know examples of pleadings. Examples of pleadings are like, for example, a notice of motion is an example of a pleading like that. Even chamber summons is also an example of a pleading. There are different types of pleadings. Okay, thank you.
Thank you, Solomon. But then you'll come to learn that what you have mentioned is actually they're actually not pleadings. They're not pleadings. So okay, generally a pleading is how you commence a suit, and whatever you've mentioned, those are applications. Those are applications. So a pleading is that document which you use to commence a suit. That's just summarily what a pleading is. Someone has typed something in the chat. Let me see. Pleadings could be documents that advocates prepare to state their cause and make claims. Yeah, that's true. That's true. You use pleadings to make your claims. So Solomon, notice of motion and chamber summons, unfortunately, are not pleadings, but don't worry, baby steps will get there. So you can look for the definition on Section 2 of the Civil Procedure Act on what pleadings are. So, and on chamber summons and notice of motion, look at the case of Jacinta M versus Jane Wangari Mwangi. So utapata that those two are not they're not pleadings, they're applications. So pleading basically, venye nimesema, they are the documents which you use to commence a suit, and examples of pleadings. Maybe we can have an interactive discussion. Anyone, just feel free. There's no right and wrong answer here. Tuko hapa ndo we correct each other and know the right thing. Anyone? Examples of
Please repeat.
pleadings? Pardon?
Well,
Could you repeat the
hello.
citation of that?
Jacinta M versus Jane Wangari Mwangi. I don't have the full citation. Those are just things to be lightly in class. Someone was speaking.
Melody. I think an example of a pleading is a plaint.
Yes, thank you, Melody. A plaint is a pleading. Anyone else?
Just to try, a pleading could be a statement of claim.
Yeah, statement of claim is also a pleading. That's true. Anyone else?
A petition.
Yes, a petition is also a pleading. You guys are doing good. You guys are doing good. Any other type of pleading?
Statement of defense.
Yeah, statement of defense is a pleading. Yes. Yeah, so basically those are among the pleadings that we have. So what is the importance of pleadings? Like you've mentioned a plaint. Why do you think one has to draft a plaint? You can't just go to court and start stating your problem or your dispute. Feel free to try. Why are pleadings important? Just unmute and give us an answer.
May I?
Please proceed.
Okay. The importance is that when you file the required documents in court, it states the facts because the court does not know your facts. So it states the facts and the prayers that you are asking for and what actually happened as to what arose the cause of action, what brought up the cause of action rather. Yeah.
Oh, hi, Lynn. Thank you. That's true. pleadings actually summarize your facts, because a lot might have happened, but then you have to put it in a document. So it summarizes your facts so that court can understand what actually happened, and it also states what you're seeking, because you can just draw pleadings without asking, without putting putting in there what you're asking from court. So yeah, you'll say you're praying for this. For example, in a plaint, so you'll have the clause reasons wherefore that and that and that. It will state what has happened, and then now what you're seeking, maybe special damages, general damages, and then you specify. That's true. Thank you, Lynn. Any other person on importance of a pleading? Guys, tuongee. You can raise your hand or you can unmute and talk.
Hello.
Hi, Kariuk.
On the other end, I would say that pleadings allow for, what shall I say, lodging of a defense to the claims to the suit that has been instituted. So you get a chance to tell the court your side of the story through the statement of defense.
You're not clear. Could you repeat? You're not so clear. Kindly.
Okay, I'm saying that on the other end, the pleadings could be used to, okay, not pleadings really. They could be used to give the court an adverse side of the story. So like if a suit has been instituted against you, you get a chance to tell the court your side of the story through the statement of defense.
Yeah, that's true. That's true. So in summary, we'll say it facilitates a fair hearing, because it would be unfair for someone to just draft a pleading, take it to court, and then court just proceeds to act based on that, on what may be a plaint. So there needs to be that statement of defense, and by filing your statement of defense, it means there is a fair hearing. So you're right, Kariuki. Any other person?
Very try.
Yes.
I think that pleadings they offer like a record of what has happened. Like if you, let's say when you want to appeal, the pleadings act as a record of what happened.
I can't quite get it clear. The pleadings act as a record of what happened. Oh yeah, that's true. That's true. It's among stating the facts of what had transpired. That's true. And Tongai, I've seen you've typed something. Could you just speak it up so that everyone is engaged? Tongai. Oh well. So importance of pleadings, as has been mentioned. So one is to facilitate a fair hearing. That has been explained because it allows you to tell your side of the story, so that court will not just decide based on one side. And it also summarizes your case, therefore saving the court's time, so that you don't have to go and say stories over stories. And then the problem with stating a lot of stories is that court will not really know why exactly are we here in court. You might be going to court for maybe a dispute in contract, but then you want to bring other things that occurred outside the contract. So yeah, it summarizes your case, and then it saves the court's time. And then it gives reference to who are the party and which is the court that is being approached. So normally in a pleading, there's the caption part. So the caption ni hapo juu, where we have the Republic of Kenya, maybe in the High Court at Kiambu, case number this and this. so and so versus so and so. So you see, it gives reference to which court are we approaching, which has the effect of jurisdiction, and then who are the parties in this case. And also it identifies the course of action. So for example, in a plaint, reasons wherefore. In a petition, you state why you're aggrieved on or your rights that have been violated. Etc. In a statement of claim, there's the part where you state like what occurred. Statement of claims is used in the Employment and Labor Relations Court. So yeah, the course of action is stated there, and then it is also used as a record because court when you're approaching court, you file the document, maybe it's physical or the digital one. So it is kept as a record for future reference. Maybe if you want to appeal, it can be referred that you filed this document in court. And then there's the avoiding trial by ambush, more like fair hearing, where now you're given a chance to defend yourself. Yeah. And it helps avoid irrelevancy and narrow down on the issue so that you know very well when you can't state facts from all over, and then now you want to come and plead and ask for prayers concerning some other things, so that the prayers you're asking for has to be in line with whatever was in your facts. So yeah, for pleadings, you'll go and look at Order 2 of the Civil Procedure Rules. But yeah, with time, these things will be easy. There's a hand that has been raised. And Opio Brian.
Hello, Donna. I'm sorry for interjecting while you are still speaking, but I had already typed a question in the chat, but I don't think you'd seen it. My question is, can demand letters be considered as pleading, since you cannot institute a civil suit without starting with a demand letter? Thank you.
Thank you for the question, Brian. A demand letter is not a pleading. It is not a pleading. So demand letter, it is this document that you first use to try and solve, let me not say solve, but you air out your grievance with the other party. You tell them that this and this happened. If you don't do this by this, if you don't maybe pay the money, or if you don't apologize within 7 days, then we'll proceed and take a legal action against you. So it is just an attempt to try and solve the case before going to court. You understand? Though it is one document that you'll present as evidence, not as a pleading, as evidence in court. So a demand letter is not a pleading. Is that okay, Brian?
Yes, it is. I've understood you. Thank you.
You're welcome. You're welcome. So yeah, those are the importance of pleadings, and the types of pleadings, as we had said. Okay, before we go to the types, there is normally the amendment of pleadings. What do you guys that's some very anyway. What do you understand by amendment of a pleading? To amend a pleading, just in simple terms, in simple English or Swahili. Anyone? Nyongesa?
Okay, I think amendment of pleadings simply means making the corrections which are necessary on a pleading. So when you make corrections, that's the meaning of amendment.
Yeah, that's true. In simple terms, the word speaks for itself. It's just to make some changes or corrections. Yeah, so for amendment, you can amend based on maybe a defense that has been filed, or maybe something else occurs, maybe one party has died, and so you need to amend it to maybe remove them from the suit. Though that may be another application, but yeah. Anyway, amendment, you'll find it in Order 8 of the Civil Procedure Rules. Yeah, So each party, both the plaintiff and defendant, or the petitioner and the respondent, both parties, the people who are instituting the suit, have a chance to amend once without leave of court before close of pleadings. Well, we are getting into so complex things, and I know you guys are just into introduction. I hope that's not too much, but there are things you'll know in the end anyway. So lazima tu tuzifanye. So each party is allowed to amend once before close of pleadings. You'll go and research when pleadings close. Maybe that can be a discussion for the next class. So after pleadings have closed, you have to seek leave from court to amend. So you can seek leave informally, like orally before court. Just go to court, ask court if they can give you maybe 14 days to amend your pleadings. Yeah, so that's informally, or you can do it by an application. So application in this sense now will be the notice of motion, which I can't remember who had stated that is a pleading no. So in this case, it's an application. You'll do a notice of motion to court. And yeah, so court may allow or may not allow. And when you're asking to amend, there are some conditions. Yeah, there are some conditions. So it must be in good faith. You can just amend in bad faith. Maybe I don't have a consent example, but you understand, you must do it in good faith. It must not be malicious, the amendment. And then it needs to be prompt. As soon as you notice that there's something that needs to be amended in your pleading, you immediately seek leave of court. You don't wait for the hearing to proceed. Is when now you come that you want to amend. It is something you had noted earlier. This saves court time plus, yeah, it saves court time plus your time as litigators. So how to amend pleadings? But these are things we did in undergrad, so tutakumbushana tu, plus pia will come to learn of them in class. So how you amend, when you're doing, oh, sorry, not when you do. So below the heading plaint, you state the date when court gave you leave to amend. That is if you sought for leave of court to amend. So you will indicate the date when you're given the leave to amend. And then whatever you want to remove, strike it out in red. You strike it out in red, and if you're adding anything, you underline also in red. So yeah, that's it for amendment. It's not really something big, but it's a testable question in CLE. It is a question that can be tested. So you'll just go and learn more. So now we're just doing a recap. And on the title there, you don't just say plaint. There'll be the plaint, you strike it out, and then amended plaint in red. That's it. Any questions so far? Can I get if we are together? Yes, Ntongai.
Yes. Hi, everyone, and particularly Donna. Apologies because you had, called on me to speak, but I couldn't because we just arrived home, so I was really in a very loud place. That's why I could not speak. But my question particularly is on, we've been informed in KSL the need to be perfect and to show conduct becoming of an advocate, in that the documents that we submit in court must be very particular, the details and everything. But I just wanted to shed light on the reality of it all. Like, is it like a commonality for such mistakes to happen? And does the court really impose sanctions on you when you make such mistakes? Or, for example, let's say you wanted to amend, but then maybe you failed to make the application in court so that you can be given leave, but you realize it later and you want to amend. Is there leniency in the outside world, or it's just as the lecturers, exclaim that it's so strict, there's no room for mistakes? Yeah.
Well, Moses, when you say mistakes, you mean mistakes that you need to file an amended pleading, right?
Yeah, or generally just like any procedural mistake. Let me just put it like that.
Okay, obviously, as you've been told, and the lecturers are quite correct, you have to showcase conduct of an advocate. You just can't carry out yourself like a lay person. You didn't go through this all these years to come and now, make some very obvious mistakes. But then there are normally those like mistakes that you can't avoid. I'll give you an example. We were doing some suit, and then the person who was being sued, we realized later it's a fact that we had not known before, but that the person had died and alikuwa hapo defendant. So, we had to amend to remove their name. Fortunately, it was before close of pleadings. So in that suit, in case maybe we had known that the person had died, but we sat on that and then proceeded until hearing of the suit is when now we want to come up and say, oh, so and so died. Yet you had all that time, maybe during service and all that, to try and serve them, and and you were not able. So it's not conduct of an advocate. So there's I really can't say there's leniency. But then there are those mistakes that you can't avoid. But in whatever you do, you can't be perfect, but you have to do like the best you can possible. Yeah, if it's a mistake, it shouldn't be those very obvious mistakes like typos or maybe just shoddy work. Just do some good work as an advocate and as a lawyer at this point. Have I answered your question?
Yes, thank you.
Yeah. So there are some obvious mistakes that really ata ukimake, even the judge will not take you as a very serious person, and it may cost your case in the end. Any other person? Are we together? Are we all together?
Yes.
And I guess actions, maybe thumbs. Isikuwe tuko watu watatu. Thank you. Thank you, everyone. So we'll proceed with the particular pleadings. So first we have a plaint. So plaint, you'll find it under Order 4 of the Civil Procedure Rules. So I don't know whether to say it. No, it's not the name. It's not the default. No, it's not. But it's basically used in most cases. For example, contract, just kawaida civil disputes, you'll use a plaint to approach court. Yeah. So the plaint must state the track of the case. So track, you'll find it in Order 4. So there's fast track, multi-track, and then small claims. Yeah, you can read through Order 4 to understand those tracks. And then you have to give the name, description, place of residence of parties, address for service, name of the defendant must be there. And so in a plaint, normally, since it's just when you're starting, the address for the defendant will normally be the plaintiff's office. And parties in a plaint are plaintiff and defendant. Take note, plaintiff and defendant. Yeah. So the body should be numbered in paragraphs consecutively, and they should state now the facts logically as according to how they happened. Your grievances, like for example, like umekosewa nini? Sorry, my mind is a bit clouded. Yeah. And you have to state that the court has jurisdiction. For jurisdiction, I know you people have done that. So jurisdiction ya magistrate court equal to this extent, the pecuniary jurisdiction obviously, for example, matters 20 million and below, and then for high court, it's above 20 million. Yeah, so you won't go with a claim that is above 20 million to the magistrate's court. That one utakuwa uko against the pecuniary jurisdiction and your suit may be struck out. So you have to invoke jurisdiction and you state that the suit is not res judicata. You have to put your prayer specifically. Maybe you're seeking for general damages of this amount. And if it is special damages, make sure you have proof. Yes, special damages, you'll come to learn of those damages later on, what both mean. And yeah, and a plaint will normally be accompanied by a verifying affidavit. So the verifying affidavit should be deponed by the plaintiff or the defendant. Okay, that's a statement, but by the plaintiff. And if it's a company, maybe the director, yeah. So that's that. And yeah, it will be accompanied also by a list of documents, list of witnesses, the witness statement, and the necessary documents. And normally you'll find in exams when you're asked to draft a plaint, unless they ask you to draft the accompanying documents, do not draft the list of documents, the witness statements, maybe even the documents that you want to start drafting maybe police abstracts. No, just do the plaint and the verifying affidavit. That one you have to know. The plaint lazima ikue accompanied a verifying affidavit. Unless you're instructed not to do that, or which that I've never seen, plaint lazima iendane na verifying affidavit. Are we okay? Up to there, any question on plaint? Okay, so after plaint, let's do a statement of claim. It's also known as memorandum of claim. So this one is used in the Employment and Labor Relations Court. And it is like in terms of format, it is different from a plaint. So it will state the name and address of both the claimant and respondents, the factual issues. And in the statement of claim, you can cite laws. Unlike in a plaint where you can't cite laws. I can't see your name, but 2024-0857. Proceed.
Hi,
Hi.
my name is Susan. Okay,
Yes.
I don't know if it's a question or an addition. So you've said a statement of claim is used in employment matters. So I think we also have a statement of claim and the small claims court, if I'm not wrong.
Okay, the small claims court normally has its own like a specific. There's a document I've never quite read. Maybe it's a statement of claim. I'm not quite sure. But this other statement of claim is specific.
Yes, it is a statement of claim.
So blanks, yeah, but I think it's a statement of claim. I think. Edward, ulikuwa unaongea?
Sijaongea.
Lynn.
Oh, I just wanted to answer that. In the rules, in the small claims court rule, there is a prescribed form of the statement of claim. So normally,
Yeah, it's a prescribed form, so maybe we can also call it statement of claim, but the one we are speaking of right now is the one that is specific to the ELRC, Employment and Labor Relations Court, established under Article 162. Yeah, so in that you can cite laws, the pleadings, and yeah, there's really nothing much. There's nothing much, and you'll just go through that ELRC Court Act. And then we have another pleading, originating summons. This is found under Order 37 of the Civil Procedure Rules. Yes, Jacinta.
I have a question regarding a statement of claim, the one for ELRC, because okay, generally there's this rule of pleading yenye inasemanga pleadings should only be regarding matters of fact and not law. So if kwa hiyo statement of claim you will include cases, does that mean it's going against that rule of pleading? I think is it order 2? Yeah.
Okay, for a statement of claim or memorandum of claim to be filed in the ELRC, you're actually allowed. There's normally that in pleadings you cannot plead the law, but then there's the exception when it comes to statement of claim. You are allowed to cite laws. Okay, the case law, I'm not sure, but laws, for example, convention, yeah. So there's an exception in the statement of claim for ELRC. Is that okay, Jacinta?
Yeah.
Yeah. So it's an exception. You can plead law. So on originating summons, Order 37. So it's also a pleading, and it's used in, for example, interpleader, adverse possession, when you're seeking to an extension of time. For example, you want to file a matter outside the allowed time limitation. There are several. You can actually find their use under Order 37 when you can use an originating summons. And yeah, so in the suit, when you're stating the case number, you'll include in brackets there OS, and yeah, state the grounds, and it is accompanied by a supporting affidavit. Yeah, that's it for originating summons. You'll find it when you're doing interpleader, when you practice drafting. Yeah, you'll do an originating summons. Yeah, that's it for originating summons. And from there's this lecturer who told us that it is used in those cases where the facts are not complicated. An OS is used where the facts are not complicated. Yeah, that's it for OS, unless there's a question so far. Okay, so OS is accompanied by a supporting affidavit. Then you will also put the evidence, the witness statements, and the documents. And then we have a petition also as a pleading. So there are several petitions. Kuna constitutional petition, there's a petition during the presidential election dispute, divorce, etc. So there's this statute known as the Mutunga rules. I don't know, I've never seemed to get the full citation of the case of the statute, but summarily it is Mutunga rules. It guides on constitutional petition, on maybe the format and all that. So petitions are wide, there are a lot. So for example, in a constitutional petition, you have to be specific, you have to state which articles or which rights have been violated in the constitution, the prayers you're seeking, describe the parties. Yeah. The election petition, they are guided by the Supreme Court rules. Yeah, it sets out the format in which you're supposed to do the petition for the presidential election, whatever. For divorce petition, it's also just I don't know how to describe it, but yeah, divorce, you approach the court through petition, and petition is accompanied by a supporting affidavit. Are we okay? Tuko sawa? You guys can even see thumbs up.
Tuko sawa.
Thank you. Someone has raised their hand. I can't see from my end.
I have a question. Is there a difference between a supporting affidavit and a verifying affidavit?
Yes, there's a difference between a verifying affidavit and a supporting affidavit. So for verifying affidavit, it just sorry for using the same word, but it just states that you're verifying the contents of that pleading and that they are true and all that. That's verifying affidavit. For supporting affidavit will normally give evidence. So it states, it is like wide in a state the let me not call them facts, but in that you will be annexing, for example, that I obtained an OB number from this and this police station and what, and then in brackets you'll say annexed and marked blah 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 is a copy of the OB. Yeah, so there's a difference in both. Is that okay?
Thank you. Yes, it is okay.
Yeah, so a supporting affidavit will be used to adduce evidence, but verifying just it confirms that whatever is in the pleading or rather plaint is true. But then in judicial review, verifying affidavit can be used to actually adduce evidence. It is complicated, but mtakuja kujua. But for now, when you're doing pleadings, we'll just have it as that. Yeah, verifying, just verify, supporting gives evidence. Are we okay until there? There's another hand that is raised. Cecilia?
Hi. Okay. On supporting affidavit and verifying affidavit, I don't know if I'm wrong, but I was told that generally affidavits, when you use affidavits, is when you want to, let's say, attach evidence. Yes. Okay, especially in supporting affidavits, you mostly use them in applications. So you're trying to support whatever you're applying for. So in supporting it, you might actually need to attach evidence. So now you do the supporting affidavit to support the application that you've just made.
Yes, that's true. For supporting affidavits, that's true. You use it to annex or give your evidence. That's true. Thank you. So yeah, as Cecilia said, you use it to give evidence. It supports your application. And it's not necessarily in applications, because we've seen you'll need a supporting affidavit when you're doing an originating summon and also the petitions. Yeah. So it's not only in applications, but can also be used in some pleadings, not all. Because you won't never do the mistake of attaching a supporting affidavit to a plaint. So yeah, so next we'll do defense. A defense is also a pleading. So in the defense, you can admit or deny. And you can also file a counterclaim together with the defense. So you'll first have the defense, the title defense and counterclaim, or defense and settle. So for counterclaim, it means that as much as this person is suing you for this, you also have a claim against them for something else. So for example, you've been sued that you caused an accident, but then you want to counterclaim that they also you want to counterclaim that they contributed to you causing that accident. So you do a defense and counterclaim, just the same title. So you first start with your defense, and then another title later, you do the counterclaim, and then you state and sign off. So defense is used to reply to a plaint, constitutional petition, yeah, etc. And you can also do a defense and a set off. So a set off means someone owes you some money, and then you sue them for that money that they owe you. But in their defense, okay, and according to them, you also owe them a certain amount of money, probably lower than or higher than what. Anyway, A owns B 500,000, and then A sues B for that 500,000. But B comes and says, you also owe me some 250,000, so we can set off this so that I pay you 250,000, and then the rest of that will compensate for the amount that you owe me. So that's set off. So you'll do it in the same way as the defense and counterclaim. You just do defense and set off as the topic there, and then you give your defense, and then now you do the set off subtopic, and then you state that they owe you this amount, so it should be set off so that you pay them now the balance. And yeah, that's for defense. So you can admit or deny, but you just don't go deny. You have to deny, and okay, when you just say the defendant denies this paragraph is denied in totality, it will not really be good to your case. Yeah. And then which other? I think those are the general pleadings that we have. So when you're responding to almost all of them, it's actually a defense or counterclaim, defense and set off, answer to a petition. But then for something like petition, you can respond through a replying affidavit. So in this case, a replying affidavit can also be considered to be a pleading in response to a petition. Yeah. So that's it for now. It was just a not recap, but it was just some small revision on pleadings generally. Yes, Cecilia?
And grounds of opposition?
Grounds of opposition, you use it to respond to an application. So you can check Order 51. I don't know which rule, but Order 51 states that you respond to an application either through a replying affidavit, grounds of opposition, or a notice of preliminary objection. Is that okay? Cecilia?
Yes.
Yeah, just check Order 51. Plus Angelo is coming to talk to us about applications, so all that will be answered. Jacinta?
Is a memorandum of appeal and a pleading?
It does not really commence a suit, but it shows your intention of wanting to appeal. So in that case, I really want to call it a pleading, because pleading you use it when you're commencing, ukianza kabisa. But for that one, it comes at the appellate stage. Yeah. But maybe we can seek the input of Angelo on this. For me, I don't think it is.
Because you see, for a memorandum of appeal, it sets out the grounds of appeal and also the what do we call them? Relief, yeah, reliefs that you want the Court of Appeal to issue to you. You see, like it's different from a notice of appeal, which that is where you show the intention of appealing. But this memorandum of appeal, which sort of like institutes an appeal in the Court of Appeal. So that's why I'm asking, can it be considered as a pleading?
The fact that it comes at the appellate stage, that means the case had already started, the dispute had already started and was decided on this court, and then now you want to proceed to the other. So in that case, honestly, I'm not quite sure, but in my opinion, it is not a pleading. It is not a pleading. But Angelo, are you in?
Good evening, colleagues. Yes, I am in, Donna. And to answer your question, it is a tough question per se, because like the way Donna said, you see it come at the stage of appeal, and if you want to consider it at that particular stage, that you are filing your appeal, that is at the Court of Appeal, then maybe to that extent we can say it is a pleading. But to your coursework, I believe they include the defense, the plaint, the petition, defense and counterclaim, and originating someone in others. But remember, the OS, that OS of application, I believe Donna had mentioned it somewhere before, because not all OS, like OS is an application and also OS is a pleading. Okay, unless if I can go and check again to see if memorandum of appeal is a pleading, because actually it sets out the ground, and I cannot say per se that you are originating your suit at the appeal. To that extent, I cannot per se say that it is a pleading or it is not. I don't know if you get me, because what your course covers are those that we have mentioned, or maybe those some that we have left out. I don't know if I'm making any sense. Who was asking the question?
I was the one who was asking the question. Okay, can we say maybe this is because the civil procedure rules do not cover appeals, and they are covered by the COA rules. So maybe that's why it's not a pleading that is listed in our coursework.
Yes, maybe.
Okay, Jacinta. So maybe not. But then you also need to understand that there's an appeal that goes from the lower court to the high court. So anyway, it's a tricky question if memorandum is a pleading. In one way, you can look at it as such. In another, it does not really fall under the ambit of what a pleading is.
Yeah, and then at the same time, maybe for purposes of the members that are in, you see this question can come only during orals, such that because some lecturer will ask you to name for him or her 4 types of pleadings. So please don't make memorandum of appeal as one of those. Or if you have forgotten about the rest, maybe make it your number 3 or make it your number 4. Let it not be the first one, because your coursework is very clear on what are the pleadings and what are the applications. Say that if you have now forgotten about all the rest, this is when now we'll go to the memorandum of appeal. Okay, so it will be oral that someone, because this one is an examination question in oral exams. But by examinations, it is very clear what you will be asked. Someone is going to ask you to draft a plaint. Someone will ask you to draft a petition. Someone is going to ask you to draft a defense. Someone is going to ask you to draft a defense and counterclaim. Someone is going to ask you to maybe respond to an application or draft a ruling or draft a judgment. Thank you.
So yeah, any other questions, Susan?
Yeah,
Your
I
hand
also
is
wanted
up.
to ask, is a reply to a defense also a pleading?
No, it is not a pleading. It is not a pleading because you're responding to the pleading that was filed. The pleading itself was the defense. So reply to a defense is not a pleading. Is that okay?
Okay. Yes.
Yeah, so that's it for what you can do for today. So pleadings, we've done their importance, the types of pleadings. So what I can advise you from here, you just have a book where you do these pleadings, you draft them. It will help you because hakuna haja ikifika term 3 is when now you want to start. What is the format of an originating summons, or what is the format of a plaint? No, start as early as now so that you get used to ukiamba tu plaint, you wake up from your sleep, you're like, yeah, so the caption, the title, the track, nini, yeah, so you can just do that as early as now. Ndio ikifika November, you don't get shocked. Any question before I cede the floor to Angelo? Susan? Then LK?
It's raised from the previous. I already asked my question.
Oh, okay. LK?
Hello. Mine is not a question, but a request. Can you find some template somewhere of the pleadings we have discussed? I don't know if it's so much to ask. Some template.
It's not too much to ask. But okay, for us, there was some link that had the notes and drafts. So that's why we got the drafts. And then you'd use that to answer exam questions, for example, and then you just have a specific book for the drafts. So I'll try and find the link and then send it to the group. Is that okay?
Asante. We will wait.
Ni sawa, wacha nitafute immediately. Nyongesa Solomon?
Do we still have some district magistrate courts in Kenya?
No, there is no district magistrates court in Kenya. Those they were, I don't know whether to say done away with, but they no longer exist. Right now we have the magistrates, where we have the chief magistrate, resident magistrate, principal, SPM, those ones. There's no district magistrate.
Okay.
Yes. 0575. Sorry, I can't see your name.
Hi, my name is Winnie. Can you kindly clarify on the replying affidavit, please?
Okay, so for replying affidavit, it can be a pleading to the extent where now you're responding to a petition. So you'll do a replying affidavit. So it just goes in the same manner. The format is just the same as an affidavit, but then now it will be in response to what has been alleged in the petition, for example. So you'll say that I am the what, that this and this happened, that this and this happened. So to the extent that you're responding to, for example, a petition, then it will be a pleading. But generally, affidavits are not pleadings, but a replying affidavit will be a pleading in that case where you're responding to a petition. Is that satisfactory?
Thank you, it is.
Huh? Okay, you're welcome. If there's no question, I'll cede the floor to Angelo. It was nice. You guys interacted were interactive. Yes, Kanana, sorry, Kimathi, Kanana.
Yes, my question is with respect to the document that is used to institute advisory opinions before the Supreme Court. The reference document, is it a pleading or does it amount to a pleading?
Okay, for pleading, you're commencing a suit, but you say that one, it is just seeking an advisory opinion. So I wouldn't really call it a pleading because you're just seeking an advisory. It's not, there's no there's no dispute between a party and a party. You just want to maybe seek an interpretation of a certain article. So I won't classify it as a pleading per se. But for now, let's just focus on what is in the course outline. Oh, but for orals, yeah, it's good to think outside the box. To that extent, it's not a pleading. Yes, Kimathi?
Okay, thank you.
Yeah, it was nice interacting with you guys. So I'll cede the floor to Angelo, who will take you through applications.
All right. Please let us clap for Donna. Let us clap for Donna. Makofi bwana. She has done a good job. She was one of our brightest students last year when we were doing this program. And indeed, the results came out, and that is why she has joined us this year. So please, we appreciate her. You see, this is a sacrifice. I know, you see, there are 45 of you right now out of 1,000 or something. And people wanapiga sherehe somewhere. It is not a bad thing, but you guys are here. We also appreciate you. Please clap for yourself. Makofi bana, clap for yourself. Asanteni sana, asanteni sana. My name is Angelo. I'm going to take you through applications. But before I do that, I don't know where you are listening to this program. You might be actually in Gemini right now, but you are listening through this program, it is fine. But I would like us to maybe narrow down the course into some 8 units, some subunits, like about 8 of them, such that when you will be revising, it is going to make your work somehow less kidogo, okay? What we have just covered right now, it is the commencement of civil litigation that is called pleadings, okay? That is one among many, okay? Now, what we will do secondly is civil applications and pretrial processes. That is number 2. Number 3, or this should have been number 1, is something called parties to a suit. Very, very important, parties to a suit, okay? Number 4, interpleader. Number 4, interpleader. Then number 5, something called constitutional litigation. This has now, it has become so rampant, and I wouldn't be, let's say, surprised when I see you guys asked to draft a constitutional petition, because now constitutional petition left, right, and center, okay? So there is a lot going on right now. So I'm not sure, maybe during your time or your exams, you will be asked to draft a constitutional petition, something called constitutional litigation. Then something that doesn't meet in the CLE exams are something called trial, judgment, execution, and decrees. Those 4 things, especially on the aspect of execution, because this is where there is money. That is where there's money. Hold on 1 second. Let me. Sorry about that. So that is where there's money execution. And you know, this thing will come in third term. So it means that you will not be taught that much. And if you start doing maybe term 2, that will be better. That is trial, judgment, rulings. Rulings, when I say judgment, rulings are also there. Execution and decrees, okay? Then there's something called procedures before specialized courts and tribunal or tribunals. Such that when we are talking about specialized courts, we are talking about the Environment and Land Court. But for Environment and Land Court, remember, they use civil procedure and civil procedure rules. They don't have their own rules, the Environment and Land Courts. But remember, they have been divided now. There's land division, there's what division, you will go and look for that. There is Employment and Labor Relations Court. They have their own rules, okay? They have their own rules. That one is a specialized court. There is Small Claims Court, okay, which deal with small claims. They don't use civil procedure, okay? Unless if the Small Claims Court Act does not provide for something, that is when now you seek guidance in the civil procedure rules. Then we have numerous tribunals, but CLE, they love National Environmental Tribunal or issues relating to NEMA. Wanapenda hiyo sana, the aspect of NEMA or environment, that particular tribunal. But remember, in CLE, someone will ask you to name at least 4 or 5 tribunals. And when now you forget about legal appeals tribunal, then it now become, or is it legal education appeal or legal educational appeal tribunal or something like that? Then it becomes an issue, because when you have a problem with KSL, where do you go? Okay. Then finally, this one, it is not taught much as KSL, but practically when you come out here, something called costs. Okay. It is a different aspect of law, cost litigation, whereby you file a bill of cost so that you can claim your money from a client who hasn't paid, or maybe party and party where you have won a case. Okay, I just wanted to give you guys that particular snapshot, about 8 or 9, so that you can know where you want to go. For example, if you can now go to your course outline, you can know where you want to begin. But let's say on this aspect of interlocutory applications, okay? Let's say, for example, the year, what will you do in this particular circumstance? Let me read something. The year is 2024. You have just been admitted to the bar and you are an associate at the firm of TTT Law LLP. The firm practices law in Mashambani town where there is no internet. Virtual court proceedings are therefore things that the residents of Mashambani only read about on Facebook. You have a lot of change to spare. You get a reasonable stipend and life is very cheap in Mashambani. You therefore have a lot of change to spare. You are soon a common feature in the local at Mashambani, even on weekdays. One Monday morning, after taking one too many, you wake up at 11 a.m. After it immediately hit you that you had been allocated a matter to attend court for a hearing where you were representing the plaintiff and which was coming up for hearing. You look at your phone and find that there are 300 missed calls from the client. Your boss, even your boyfriend. You dress hurriedly and rush to court. You find that the matter was dismissed for non-attendance. Crestfallen, you go to the office. Your boss is obviously angry at you, but is not willing to fire you. Not just yet. It is not easy to get an associate in Mashambani after all. She angrily tells you to sort out this mess. What will you do? Okay? There is this matter that has been dismissed for non-attendance. Okay? So what do you do in that particular circumstance? Can anyone tell us what you can do in this instance whereby you are busy at attending a party at the former 1824? Unfortunately, you guys will not test it. It was demolished the other day. Can someone tell us, let's say if the matter has been dismissed for non-attendance, what do you do? Or what will you do in the circumstances? Anyone, please, on something that I have just read? Chap, chap, guys, chap, chap, guys. A matter has been dismissed for non-attendance. What do you do?
You apply for reinstatement.
Who is that? Who was speaking? Who was speaking, please? You can speak up. Yes, guys, that was very good for that person. It is good to speak up that particular person who was who said that you apply for reinstatement. Yes, you raise your hand, speak your mind. It is an interactive session, and that was very good. Okay, you have to apply for reinstatement of that particular suit. You will be required to file an application for reinstatement. Okay. Who was that?
My name is Blair Samuel.
Yes, Blair Samuel.
Yes.
Yes,
If a matter has been dismissed for non-appearance,
Mm.
you file an application for reinstatement, but has to be supported by an affidavit.
Thank you. Yes, you make an application for reinstatement. Let me read another one. You are handling a matter where where the course of action is breach of contract. The matter is coming up for hearing in a week's time. One evening while going through your file in preparation, you realize that you indicated the date when the course of action arose as 28th July 2008 instead of 28th July 2018. The defense of the defendant is that the course of action is time barred. What do you do? Anyone else? For that thing that I have just read, you have made a mistake, and I believe Donna talked about it some time back. Yes, Okola, Cecilia, take it away.
You apply for amendment of pleadings. Apply
You
to
apply
amend
for,
the plaint.
okay, you apply to amend a plaint. You file an application for amendment
Yes,
of the plaint.
that is what I think.
Okay, that is very good. There were two hands, another person. Who else? I saw two hands. You have just made some mistake. You just realized. Yes, Karaoke Mburu, take it away.
As Cecilia has said, you would apply to amend your plaint with the leave of courts.
Very good. So what kind of application do you file? Karaoke, complete your answer. Huh?
An application for amendment of plaints.
No, that is not a type of application. Yes, you are making an application for amendment, that is correct. But what type of application is that? We have chamber summons application. We have notice of motion application. What is that application? What application do you file? We have originating summons application.
I would say chamber summons.
Okay. Guru is saying chamber summons. Let's hear what Cecilia, you want to complete your answer?
A notice of motion.
Notice of motion application. line, or is it leaned?
It's just lean. I
Okay.
think it's an option.
Notice of motion application. Very good. So you file a notice of motion application. Karaoke, we will realize these applications, notice of motion application happens to be the default application. Okay. However, there are instances whereby you will be required to file a chamber summons application. Let us hear what Jensita has to say. Waitito.
I have a question. Can you make an oral application?
At the instant now you see the matter was coming up for hearing, you have to make a formal application such that the defense is given time to respond. Okay, you see their case is on that it is time barred. Even maybe they have filed a PO. Okay, so if the pleadings are closed, the way that Donna said, if they are closed, then you know you have to seek leave of the court. Yes, you can do it orally, but of course, the defense will object. They will say, you know what, let him file a formal application such that we are given an opportunity to respond. Okay. Yes, let us see again this particular scenario, ladies and gentlemen, and distinguished members of class of 2024-2025. Let's say you have been served with a plain in which the person who has sued you claims to be the friend of someone from whom you bought a car. There is no indication at all that the person who sold the vehicle is dead or is under any incapacity, and that the friend has been appointed as a guardian ad litem. What do? You have this friend of yours, or you went to buy a motor vehicle. I don't know which one iko market is Lexus what, which Mercedes or which kind of Range Rover 2023 model. But now you have defaulted in payment. Instead of the company or the person who sold you the motor vehicle, the friend to that person now comes in and say, you know what, is the one that is bringing a suit against you. Tell me what do we do in this instance, ladies and gentlemen? The way we did, Mukono Ju, let us raise our hands as we answer. What do you do?
Come up again.
I'm saying you have just been served with a plain in which the person who has sued you claims to be the friend of someone from whom you bought a car. There is no indication at all that the person who sold the motor vehicle is dead or is under an incapacity, and that the friend has been appointed as a guardian ad litem. You know, for you to appear on behalf of someone, there must be some form of authority that would allow you to bring an action on behalf of someone. Okay? Now the friend is bringing up an action on behalf of the seller, the person who sold you the motor vehicle. There's no indication that the person who sold the motor vehicle is incapacitated, or for that matter is dead, or for that matter, the person who has sued you has been appointed as guardian ad litem. So what do you do? What application do you file? Mawakili, what application do you file in the circumstances? Yes, karaoke, sir.
Okay, I am just spitballing here. I'm not really sure, but can you say third party notice?
That is a good attempt. Third party notice is something really sweet and very easy in civil procedure, but yes, you not really, but that is a good attempt. And anyone else? Yes, Bwana Edward, talk to us, sir.
An interpleader.
Another good attempt. Good attempt, but in the circumstances, maybe not. But an interpleader is something really sweet, and you pray that it comes in your exams. Winnie Spencer, take it away.
A notice of motion.
Yes, a notice of motion, but what application are you? Which? Okay, it is a notice of motion. You see, we are talking about you apply for amendment. Okay. So let's assume it is a notice of motion, but what is this application?
Preliminary objection.
Notice of preliminary objection, something else altogether, but a good attempt. Who is that? Whose hand is that? Is that Winnie or Jacinta? Yes, Masako.
An application.
Okay. Yes, go on.
Application to strike out the pleading.
Thank you. It is a striking out application. You have said striking out pleading, which I agree, but that is 50%. There may be some part. I'm not saying that your answer is not correct. It is a striking out application. Let me see what Masako can tell us. Stella.
I had the same idea as the previous speaker.
Okay. Yes, guys. You see, when this meeting started, one thing that our leader, Bona Daniel, said was that this is the forum that we give you so that you can make all attempts as possible and we correct them. Okay? You see, for third-party notice, that is a different aspect of law whereby you claim two things from, let's say, okay, there are two parties to a suit. One is a plaintiff, one is a defendant. But now a defendant would file something called third-party notice, whereby if the defendant is claiming from someone else, such that when the defendant, let's say, is held liable for whatever, let's say it was an accident, he's saying that the problem was because maybe someone else maybe hit the motor vehicle. So those you will file third-party notice against that person for compensation or something called contribution. Okay, compensation is not the word, but there are two things. That is contribution, they can contribute. Or if not, there is these other words that are used in the civil procedure. Donna, contribution and what? There are two things that are used in the civil procedure in the case of third-party notice.
Indemnity.
Yes, indemnity.
Quite sure, but
yes, indemnity for third-party notice. And the examiner will look for those two words, indemnity and contribution. So you are saying, yes, if I'm held culpable, then I have this other person who was liable. Let's say it was an accident whereby gari ya nyuma ilikugonga, wewe ukaenda ukagonga gari ya mbele, and then your plaintiff akaumia. The plaintiff will sue you. But now you will bring in a third party who will now, if you are held liable, then that person will have to indemnify you or will contribute a certain percentage of that particular claim. Okay? Someone talked about PO. There are they 4 or 5? There are some grounds whereby you are allowed to file a PO. The aspect of striking out, it is an issue of facts. Okay, it is an issue of facts, and those facts needs to be investigated, so you will not file a PO per se. Okay, but now to the person, just was it Cecilia and Masaku who are of the same opinion? You file an application for striking out, but now there is striking out of a party, number one. Number two, there is striking out of pleadings. Okay, but in the case that I have just read out of this scenario, you will actually file for both to be strike out. Okay, if let's say, for example, you are striking out the party, you use chamber summons application, order 1 rule 14. You can go and confirm, I don't have my civil procedure, the 1 rule 14, or if it is rule 13, okay, rule 14. So you will use a chamber summons. If you are striking out the party, you use chamber summons application. But if you are striking out pleadings, order 1, order 2, sorry, order 2 rule 15, you use a notice of motion application. But since you are now doing, let's say, both, you are striking out both the pleadings and the party, then we go to the default application, that is the notice of motion application, order 51. Okay, if you have forgotten about that you are required to use a chamber summons application, please fall back to notice of motion application. Okay, so before I go any further, I would like to invite questions on those particular scenarios. Any question, ladies and gentlemen? Jacinta, please.
Okay, there's some I read hapo kwa striking out where they were saying there are 3 scenarios. You have talked about 2, striking out a party and striking over pleadings. So there was the third one, striking out a matter. So when does striking out a matter happens? Can you give us an instance?
It depends on what you mean, because in the civil procedure, it is those 2 particular scenarios that I have stated. But when a matter is struck out, it means something else. When a matter is struck out, so it might be maybe the court has ruled on that particular matter, maybe on technicality, or maybe something was not done, like the other day was before the High Court of Kenya Commercial and Tax Division, whereby the defendant in that matter had filed an application to produce some documents under the disguise of access to information under the Constitution, and also access to the right of access to information under the Constitution, and also Section 4 of the Access to Information Act. But now the judge went and did something else. She did not decide the application on merits, rather on technicality, that the person who swore the affidavit in support of the application was a foreigner. And in the circumstances, the foreigner, or maybe the companies that were there, they had foreign shareholding, they were not citizens of Kenya, and therefore they have no right of access to information. So the application was struck out. Okay, so when it was struck out, now the defendants now came and filed a similar application, but now being sworn by a Kenyan citizen. So if it is struck out, you can file it. But if, let's say, a matter, you can refile it. But let's say if the matter is dismissed, so it means that it will be res judicata. I don't know if I have gone a long route, Jacinta. I don't know if I'm answering your question.
Yeah, I'm following.
Yes. So that one is striking out a matter is something that a court can do. But when you, let's say, for example, if you have filed your applications to strike out pleading, so you see altogether the case is going to fail if you are the only defendant. So then the matter will be struck out in any event. Tuko sawa?
Yeah.
All right. Cecilia, is it Cecilia?
Cecilia.
Yes, Cecilia.
And when, let's say, the plaintiffs fail to institute their suit for more than 2 years, you file to? Can you file for the suit to be struck out?
It depends. You know, I don't know under what subtopic you will discuss it.
For want of prosecution.
Or for one of prosecution under the civil procedure.
Yes.
You see that one, you will, sometime the judiciary nowadays, they introduce NTSC, whereby if you see the suit, if you have not prosecuted, is it 2 years really or 1 year? Maybe perhaps we need to confirm, because if let's say you have not prosecuted your matter for, let's say 12 months, then it will be liable for notice to show cause. Okay, that it will be struck out, or it will be dismissed for one of prosecution. Okay, you need to confirm if it is 1 year or if it is 2 years. Okay, Cecilia?
Yes, I'm just looking for my civil procedure.
Okay. In the meantime, let me hear what Kanana Kimathi has to say. Kanana?
Yes, so my question was with respect to the application to strike out parties or pleadings. So on the first aspect of parties, now that you have told us you can make that application to strike out the parties, for instance purposes of the misjoinder. So there is this case laws that provide that a suit cannot be completely struck out on the basis of misjoinder. So I wanted to understand what recourse will the other party have? Is it now still amending their pleadings to include the right parties, or what does that like what other avenue is there, considering that it's not an absolute right that once you make an application and it is granted, that means the suit is completely struck out?
Yeah, you see, that is a good question. What will happen is you will need to file it again, but now suing the right parties. You know, misjoinder cannot really dispose of a suit. Okay? So you can add parties, you can remove parties. Okay? So it will not completely, let's say, dispose of your matter.
Okay. So that means the right application for the other party who was at fault in terms of including the right parties will be an amendment of their pleadings.
Let's say if it has been, let's say it has been strike out and maybe it was one party. So you know you will have, let's say, to file a new suit against the right party. Okay?
Okay.
Against the right party. But if there was other parties in a suit, so you know the matter will actually proceed against those parties. Indio?
Please repeat that.
I'm saying, if let's say there were first defendant, third defendant, second defendant, so you know the matter itaendelea, that party that was struck out, huyo ataenda, but the suit will proceed against these other parties.
Yes.
Tuko sawa?
Yeah.
Are we together?
Yes.
Yes. So let's hear what Jacinta, you have something for us so that we can proceed?
Mine is not a question, but it's what I think it's Cecilia had asked on striking out a matter for want of prosecution, and you are asking like the period in which now they could reconsider like the notice to show cause, and according to the civil procedure rules, it's 1 year.
Okay. So guys, it is 1 year. Thank you for that. So now, the other aspect, I was going to look at the features, the importance, and something like that, but I'm going to leave that one for you, because the nearest exam that you might do after you are done with your project work will be orals, and someone is going to ask you to at least name the types of interlocutory applications. So maybe guys, let us just go to it. We have just talked about few, but now let's talk about types of interlocutory applications. One each, guys. Types of interlocutory applications. Raise your hand, tell us one, the next person. Let's say we have 7 of them. What are these applications? Yes, Chebet, Ngeno, or Geno.
I'm going to try maybe a chamber summons.
I'm saying types of interlocutory applications. Let us do this. We have chamber summons applications. We have notice of motion applications. We have originating summons applications. Okay, leave that now. There are these, like we were just talking about striking out. I want answers to that respect. Interlocutory applications. Maybe you can try again, Chebet.
Notice of preliminary objection. Hey, play.
You are doing well. Okay, I'm saying leave alone about the names of the applications. When I say types of interlocutory applications, you can make a striking out application. That is one. What could be the others? Mary?
The pleadings. Things. Okay.
Chebet, you are saying?
I'm asking, can you say amending pleadings?
An application for amendment of pleadings. Yes, that one is an application. That one is a type of an interlocutory application.
Okay.
Yes. Yes, that is one. Very good. Mary, that was your turn.
Can we have third-party applications?
Very good. Third-party application. We just talked about it. Very good. Edward, it is your time to shine.
An application for interlocutory judgment where the defendant fails to enter appearance.
Okay. Thank you very much. So that one is an application for summary judgment, default judgment. Very good. Very good. We had someone who was having Wazungu names, but let's have LK. LK, then.
Application for injunctions.
Very good. Application for injunction. But there are a lot of injunctions. Maybe you can choose one that your colleagues can have.
Sorry, temporary injunction. Application for temporary injunctions.
Temporary or interlocutory injunction or something like that. I love that application. Very common in CLE. Ocheng Abor. Tutese.
Perhaps I can state Mareva injunction.
Another very common application, Mareva injunction. I don't want to ask what is that, but you can shine. You can Tessa Sisi. What do you mean by when you are making an application for Mareva injunction at Ocheng?
Whatever injunction is like a freezing order that pending the hearing and determination of a suit, you can set to pend, you can set to freeze, you can apply for a freezing order so that so that the defendant cannot get rid of the subject matter of the suit.
Subject matter. Very good, very good. Let us clap for Ocheng, guys. Begin Makofi. Let me start. Napiga wapi makofi? Okay. Asanteni sana. Anyone else? Ocheng, you are clapping for yourself. Okay.
Yes, I'm clapping for myself.
So, guys, let us, anyone else? Mary, you want to give her another one?
I was asking, can you say application for, is it taxation of cost or security of cost?
Yes, application for security for cost. You want to shine with that one, Mary? Okay, Jacinta, Waitito, Dr. Governor.
Application to set aside a default judgment.
Yes, and you will realize there are many of them. And you can make an application to actually have that particular judgment, default judgment set aside. Winnie? Winnie, your hand is up.
Application change an advocate.
Application?
For change of advocates.
Yes, you can make an application for change of advocate. Sometime lakini kama hujalipa wakili yako, it becomes an issue because what is needed, you have to pay, okay? Order 9, Rule 9, or you can sign a consent. Ocheng, your hand is still up. Someone is saying, Chebedi is saying application for stay of proceedings, correct? Lynn?
Can you say application to cease from acting?
To?
Cease from acting.
Yes, you can make an application to cease acting. In fact, I'm filing one now. Yes, guys, that just to name a few. Okay? Yes, you want to go again, Lynn?
Yes, I want to ask a question. So, let's say if you're questioning the jurisdiction of the court, is that also done through an application?
No, that one falls under the ambit of PO. You file a PO, a notice of preliminary objection, order 51. Okay, guys, that was very good. That was very good. And you will realize if you, okay, someone talked about an Anton Pillar. That one, those are very, very examinable aspect of the Kenya School of Law. The temporary injunction, Mareva injunction, Anton Pillar, okay, interpleader. Those are, because you see there's a way that the syllabus has been developed. There are those that will keep to be examined from time to time. So you must know where you will be targeting, okay? Like, let's say, for example, an application for striking out. I had also said before, Order 2, Rule 15. But remember, there are two types of striking out. You can strike out a party, the one that I told you, Order 1, Rule 14, whereby you use chamber summons application. But if you are striking out pleadings, that is Order 2, Rule 15. So at any stage of the proceedings, the court may order to be struck out or amended any pleadings on the grounds that, number one, it discloses no reasonable cause of action or defense in law. Number two, it is scandalous, it is frivolous, it is vexatious. And remember, time is going to come when you will really learn those things, the scandalous, the frivolous, the vexatious. What do they mean? Okay, time is going to come whereby you'll be able to learn about those. It may prejudice and embarrass or delay the fair trial of the action that you file to, you make an application for striking out. It is otherwise an abuse of the process of the court. Okay, those are the grounds under which a person makes an application for striking out. But most of the time it is a hard application to win. It isn't easy, okay, especially for those positivist judges or those, I don't know, whatever school of thought, because Article 159 is spoiling everything. Eh? Anything that will lead to technicality, although the Supreme Court has pronounced itself that the procedure or everything else form part of substantive justice, but some substantive justice always win. Okay, so court may order that suit to be stayed or dismissed or judgment to be entered accordingly as the case may be. So that is on the aspect of striking out, but you need to, there is a locus classicus case in that aspect. You can write it down. The case of DT Dobi and Co. Kenya Limited versus Mushina 1982 Kenya Law Report, that is KLR. Okay, so that is the locus classicus case of the aspect of striking out. The other case.
Can you repeat? Sorry, can you repeat?
The case of DT Dobi, the bank. DT Dobi and Co. K into bracket Limited, that is LTD, versus Mushina, MUCHINA 1982 Kenya Law Report, but actually it is reported right now. I believe you can get it in KLR. It is reported. Most of the locus class cases nowadays are reported. That is the locus classicus case there. So there are other two cases, but you can do with that for now. Let's go to the second application, summary judgment, order 36 of the CPR. But let me just point this out, guys. You know, when you are in that matatu, how do we call it? The green one. Inaitwaje? Guys, the green hii ya kupeleka watu KSN.
Naboka.
Yes, the prestigious Naboka. So you can just be reading it like the CPR, like your Bible. You don't need to cram it by the way. It is a procedure from order 1 to order 53. Okay? Order 1, you only need those 53. And by the way, it will not surprise you. You will not need all of them because others are not that important or are not used from order 1 to order 53. You don't need to cram it for now at least, but CLE, I will advise you cram if need be. So just read ukiwa kwa Naboka, or if you are using those small matters tools ya kwenda Rongai Republic. Okay, unaenda huko unakula ugali yako mayai, unaingia kwa bedsitter ya 2,500. Okay, that was something that was told to us when we were doing campaign. Some serious politician walianguka vibaya sana. I really love Rongai, lakini sawa tusijasikia vibaya. But you just need like your Bible. When you are ukiwa kwa gazebo where tu unasoma, you can be telling yourself 1 order per day. You read it. 1 order per day ukienda. You will realize maybe you just need 53 days anyway. Okay? So there are others that are really, really peculiar. For example, if someone is talking about order 45, section 80, what am I talking about? Let me assume nani huyo mwenye amesoma sana hadi tatam Order 45 and Section 80 of the Civil Procedure Act. What am I talking about? Who was that? Someone was about to say something? Anyone? Yes, Abdullahi. Abdul Kadir. Okay, sorry. Demi? Demir?
Review.
Yes, thank you. That is an application for review. Of course, there are those that you know isn't lazima. Na sasa ndio hii umeshajua saa review. Someone is going to ask you in orals na bado itakuja CLE. You have no reason to fail at all. Naona. So let us talk about, for example, summary judgment. Order 36 of the CPR. So if a defendant has appeared but has not filed a defense, then the plaintiff can apply for summary judgment for the amount claimed or part thereof, and interest, or for recovery of the land and rent or means profit. Because you see there are these things, when we will be beginning our oral sessions, you will realize I will ask you what is the difference between summary judgment and default judgment. Okay? Then you will have to tell us. For example, in the summary judgment, you have filed, the defendant has not appeared. The defendant has appeared but has elected not to file a defense. Okay, summary judgment. Default judgment, no appearance has been entered, no defense has been filed. Okay, so you will realize here there are always some specifics that are needed. Let's say when you are explaining something, and that is why sometimes you approach things with sober mind. For example, there are conditions through which, let's say, the plaintiff must be seeking judgment for. For example, a liquidated demand with or without interest. Okay, when I'm talking about a liquidated demand, what do I mean? Anyone, please? Liquidated demand? Anyone? Anyone, guys? Liquidated demand? Yes, Ocheng.
Yes, I can give a trial.
Yes, yes.
Liquidated demand specifically means that the plaintiff and the defendant had agreed on certain terms and conditions, and they have agreed on specific amount of money, and it is that specific amount of money.
Okay, thank you. Thank you. Cecilia, you don't need to lower your hands. Cecilia, surprise us.
Okay, I nearly wanted to say the same thing. An amount that can actually be ascertained. If you want 10,000 shillings from the other person, it's 10,000 shillings. It's not like general damages, and it's a specified amount of money that you're seeking.
Thank you. Yes, liquidated demand. So let's say you are claiming for rent. Rent is 500,000. So it is 500,000. Okay, there are no general damages or some assessment that is needed. Or let's say if an assessment is needed, what do you do? Let's say you have applied for summary judgment. What then do you do? Let's say, what do you pray for then? Let's say maybe the amount is unliquidated. What is the next step? There is hearing that is done. What hearing is that? Anyone? Yes, Edward.
It's a formal proof hearing.
Formal proof hearing. Formal proof hearing. Jacinta?
I wanted to say the same.
Thank you. Formal proof hearing. So you pray for summary judgment to be entered, but now since the amount is unliquidated, then you pray for a date for formal proof hearing. This is where now the court is going to do some assessment. Okay? And by the way, before I forget, I don't know if we are going to have a date for civil procedure for the civil litigation again. There is some decision that was recently rendered by Justice Professor Sifuna, whereby he said that the government cannot hide behind the Government Proceedings Act, because you know default judgment cannot be entered against the government, as the law is. The judge has proposed for the Government Proceedings Act to be amended, and that also apply to the civil procedure. Please look for that judgment. It will form part of your hearing, of your orals, and maybe some people will try to confuse you because it is not yet law, but he has made recommendation. It came out like, I don't know, last week. You need to look for that. Okay, so that is it. Liquidated demand with or without interest. B, the recovery of land with or without a claim for rent or means profit by a landlord from a tenant whose term has expired or been determined by notice to quit or been forfeited for non-payment of rent or for breach of covenant or against persons claiming under such tenants or against a trespasser. Okay, so summary judgment shall be supported by an affidavit either of the plaintiff or some other person who can swear positively to the fact verifying the cause of action and any amount claimed. So guys, I'm going to give you one authority here. Attorney General versus Halal Meat Products Limited, 2016 EKLR. Okay, anything that we will be discussing, I will be giving you one authority. Okay. Attorney General versus Halal Meat Products Limited, 2016 EKLR on summary judgment. Common questions in what? In orals and also maybe bar exams. Edward, your hand is up. We are about to finish, guys. Don't run away. All right, guys, let's now look something else, something called Mareva injunctions. Very common aspect of, let's say, our course, Order 39. Okay. Order 39. So, guys, Order 39, Rule 5 and 6. So this is, it could be said, and is a statutory codification of an interlocutory relief, commonly known as Mareva injunction or freezing order. The famous case of Mareva Compania Navera SA versus International Bulk Carriers, 1980, All England report. Okay, you will look at that. We have Anton Piller. Okay, so Anton Piller, so this is an order granting the right to search, take inventory, and seize evidence without prior warning. Let's say, especially for these copyright matters, whereby some people piracy, people copying here and there. Okay, you don't need to give, let's say, that person a demand notice or something like that. The evidence will go away. So you just make an application, Anton Piller, seeking Anton Piller orders. Okay, the famous case of Anton Piller, KG versus Manufacturing Processes Limited and others, 1976, All England report. Okay, temporary injunction is found under Order 40. Okay, so you want in any suit, let's say you want, let's say, for the subject matter to be preserved for that period of the suit or during the pendency of the suit. Okay, in any suit for restraining the defendant from committing a breach of contract or other injury of any kind, whether compensation is claimed in the suit or not. But here, I wanted you guys to know that particular case on temporary injunction. By the way, very, very common. What is the locus classicus case on temporary injunction? Anyone? We are about to conclude, guys. Anyone? Yes, Abdul Kadir.
Giela versus Casman Brown.
Yes, even in your interviews for pupillage. Even in your interviews for pupillage, someone is going to ask you about the principles. Okay? Under the case of Giela versus Casman Brown. And then again, Kuharibu Zaidi, someone is going to ask, what is the Kenyan case? Okay, the Kenyan authority that codified or adopted, let's say the Giela versus Casman Brown. What is that Kenyan authority? I know there is another one called American Cyanamide Company Limited versus Ethicon Limited, 1975, AC 396. What is that Kenyan case? Okay, you will look at it. There is Kihara versus Barclays Bank of Kenya, 2001 EA. Okay, then look at Global Real Estate versus Immune Mancini and Sarah Farrar, 2014 EKLR. Okay, what are the principles in Giela versus Casman Brown? Please look at it. But tafadhali, don't let me down. If someone asks you the equivalent of Giela versus Casman Brown, it is this case, Murao Limited. Are we together, guys? The equivalent of Giela versus Casman Brown. Murao Limited versus First American Bank of Kenya Limited and two others. 2003 Kenya Law Reports. Tuko pamoja? Oral exams. Okay.
Kindly say that again, please.
Okay. Since umesema vizuri, it is called MRAO, like MRAO Limited. That is LTD versus First American Bank of Kenya Limited and two others, 2003 KLR 125. You can unaweza shine vibaya sana huko interview yako ya pupillage. Anyway, sikuwa hizi Peter, I don't know why. I believe the problem was not me, the problem was my handwriting. So they did not agree with my handwriting. I did another one as MMC Asafo, did my almost CLD. He said I did not agree with my handwriting. Okay, I don't have the worst handwriting though. I can try. At least CLE agreed with me. So I don't care about whatever they say. But anyway, guys, those are the applications that I wanted to talk about. Mandatory injunction, the security focus. I can see it is 2218. So guys, the floor now is yours. If you have someone, some questions to me or to Donna, I don't know if we will be given another chance again. But if there was another one, ningependa sana kuongelea mambo na my execution trial judgment, because those ones you will not be taught that much because inakwanga uko term 3. And my favorite topic, interpleader. Interpleader. I really like that one a lot. I practice civil litigation, by the way. So yes, guys, that is what we had planned for today. Donna took you through pleadings. I have now completed the aspect of applications. So anyone, if you have any question to me or to my colleague Donna, please, this is the time. We can let you guys go and encourage you to invite your friends. Who knows, maybe next weekend we'll be dealing with conveyancing or criminal litigation. So anyone, any question, please? Yes, thank you, LK. Talk to us.
Thank you for taking us through that. But again, I want to request for templates if it's possible for the said application.
All right. Thank you. I don't know who will be the coordinator. We can, it is easy to send to the email, then to be shared among your groups. I don't know, we'll try, that is not a problem. Thank you, LK. Anyone else? I believe Donna was to send you a link.
Yes, she said she will.
Okay, okay. Yes, anyone else, guys, before we conclude? Okay, Donna, you have something to say?
So thank you everyone for participating. May we continue the same spirit. Civil, among the civil should be the easiest because they're straightforward things. So just do the practice drafting venye nimewambia, and I'm sending the link. So that's all. Keep up with the spirit. All the best and good night.
Okay, thank you so much, Donna. Thank you again to all of you for taking this time to join us. I know we will do much later in the course of your studies at the Kenya School of Law. At least we wanted to give you guys a breakdown. This is not all of it. There are other good topics that are here within civil litigation. I know we will try our best if we will be given another chance to maybe take you through civil litigation before we start our orals. So that will be really okay. We will try our best. We love to give back. I am a product of this program. Donna is, and I believe even Daniel also, and most of the members of our team. And we encourage you to bring your members. Last year, a session like this would have over 300 people. I'm not saying that this number is not much, it is okay, but just come, let's learn together, and we believe you guys will pass your exams. So maybe I can ask Jacinta. Jacinta, maybe you can pray for us, please. Thank you all.
Okay. Let's pray. The name of the Father, the Son, and the Holy Spirit. Amen. Father, we come before you this evening. We thank you and any question that you have given us. We thank you for instructor who have taught us a lot, that is the prudence, and we bless them with wisdom and knowledge so that they can teach us more I also pray that you may guide all of us through this ATP program, that as we continue learning a lot, may you give us wisdom and knowledge to understand all of it. As we retire to sleep, may your guardian angel be with us as we sleep. I pray, trusting and believe in Jesus' name. Amen. In the name of the Father, the Son, and the Holy Spirit. Amen.
Amen. Amen. Thank you, guys. Good night and all the best. See you next weekend. Members can leave at their own pleasure.
Good night. Thank you.
Night.
Good night. Thank you.
Yeah.
Thank you.